precipitation, mostly snow to the north of I-70 and ice south of I-70 is what they're calling for right now. We're going to stay on top of that throughout the day, and we'll be hearing from Glenn Zimmerman throughout the morning as they continue to track this major winter storm bearing down on us. A big story in Washington yesterday involving a St. Louis icon company, Monsanto, and a very interesting case. It's Bowman versus Monsanto, and the United States is representing and supporting Monsanto's position, and they're taking on a farmer. That's the Bowman side of the case. And if I have the case right, basically it's a case where a farmer has reproduced a seed, and I'm very kind of 30,000-foot paraphrasing, reproduced a seed that was a hybrid seed of Monsanto and took it to several generations, and basically they're saying that he is infringing on their patent rights. And a person who sat in that courtroom to hear the opening oral arguments yesterday is Krista Cox, and she joins us by phone. Good morning, Krista. How are you?
Good morning. I'm doing well. Thank you.
And again, I gave the 30,000-foot view. Am I close to what this case is all about, that Monsanto feels that their rights were infringed upon by a farmer who took some seeds that he got from a grain elevator and has now taken them to a couple more generations?
That's exactly what the case is about. The case is about Bowman, as you mentioned, bought the seeds from a grain elevator, planted them, and created new seeds, which carried the same characteristics as Monsanto's patented seeds. And Monsanto says that that's a newly infringing article, so anytime Bowman then replants those later generation seeds, Bowman is infringing on Monsanto's patent.
But in past cases, have we not seen where oftentimes the court has chosen the purchaser's rights over the patentee's rights? In cases like this?
Well, yes and no. So the Supreme Court has a very long history of applying strict patent exhaustion doctrine, which basically means that once a first sale of an item occurs, the patent holder can no longer control the rights to that item, and those rights pass on to the purchaser. But what makes this case really unique, and I think all the justices at oral argument agreed yesterday, as well as all the parties to the case, the United States, the attorney for Monsanto and attorney for Bowman, all kind of conceded that this is a really novel case because it involves patent exhaustion for self-replicating technology, meaning like a seed or other forms of self-replicating technology, could be bacteria or cell lines, and the court has never decided a case on whether or not patent exhaustion will apply to self-replicating technology, and more specifically to later generations of that technology.
We're speaking with Krista Cox, who's a staff attorney for Knowledge Ecology International. Do you guys have a position on this, or are you just very curious to see what's going to happen because of the agricultural impact?
Well, we do have a strong interest in the case. We actually filed an amicus brief in the case supporting the petitioner, who is Bowman, the farmer in this case. Our interest, we actually work more in the access to medicines and access to knowledge fields. Mm-hmm. And our concerns about this are that we don't really know yet what the potential consequences for the case will be on the biotech industry, because there's a lot of uses of self-replicating technology that involve cell lines, DNA or RNA sequences, virus strains, microorganisms. And because self-replicating technology and patenting of the self-replicating technology is a relatively new field, we're just concerned that if the Supreme Court creates a new exception to the patent exhaustion doctrine, it could have negative and unknown effects on the biotech industry and access to medicines or access to diagnostics.
Isn't it somewhat unique in this case, however, because, you could make the argument that this isn't being recreated in a lab. Farmers are just, taking a seed, planting it, spraying it, and then praying that it grows. It's not necessarily a replication, if you will, of technology. It's just simply the natural process of continuing on what they do.
Well, absolutely, and that's certainly one of the arguments that Mr. Walters, the attorney for Mr. Bowman, made yesterday, that this doesn't require a creative process. It's not like Bowman was himself, doing anything in particular to replicate the seed. He was just planting it, and a natural function of the seed is to grow Chief Justice Roberts made a comment basically like, you throw all the seeds on the ground, one or two is probably going to grow and self-replicate, even if the farmer doesn't really do anything else to it. So it is a unique aspect to the case.
During opening arguments, did you get a sense where any of the justices are coming down in their questioning and where they may stand on this? Sometimes they tip their hand a bit when in the way in which they're counter-arguing or counter-asking.
Sure. Well, I've actually learned that it's not a good idea to
try to predict those guys.
How the case will end up. But I would say that the questioning yesterday tended to favor Monsanto's side, much to my own concerns. But I think that in particular, Justice Breyer, his line of questioning was quite concerned about Bowman's line of reasoning. I think most of the justices had some concerns on both sides, as they usually do. Usually both sides get questioned quite a bit, but I do think that the questioning favored Monsanto.
And what is Monsanto basically trying to say, that their patent has not exhausted simply because they sold one set of seeds, that they have the rights to the future generations of all seeds that come from that initial product sold?
That's exactly what Monsanto's point was, and one of the attorneys, Ms. Arbus-Sherry, she was arguing on the behalf of the United States, and she had an interesting exchange with Chief Justice Roberts, where Chief Justice Roberts wanted to know exactly when Monsanto believed that their patent rights had been exhausted, and Chief Justice Roberts says, so basically you're saying that it's only exhausted with respect to the one bean, and Ms. Arbus-Sherry said, yes, that's exactly it. It's only with that one seed. Once the person plants it and creates a new seed, its rights are never exhausted in those future seeds.
And the attorney went on to point out that it's much like a software purchase, correct? That you just don't make a purchase of a software, and the person who buys that piece of software are allowed to go out and replicate it multiple times. Right,
and the software example was brought up multiple times yesterday. I have a few concerns with that hypothetical, though. Software, in the way that it was being discussed yesterday, was they kept bringing up an example of, you take a software disk, you have Microsoft, and then you copy it onto another disk and you give that away. That's an infringement, and certainly that's the case, but software isn't truly self-replicating in the way that a seed is. I mean, if I put the disk in my computer, make a copy, burn another copy, I'm actually doing something to create that newly infringing article, whereas with a seed, its natural function is to reproduce and create another seed.
Very interesting case. Krista Cox, we're glad you're there, and keep us updated, will you, as this continues to go through the Supreme Court. How long do you think this case is going to be heard, and then when do we expect the decision to come down?
Well, oral arguments finished yesterday. Oral arguments lasted 1 hour, as is usually the case in the Supreme Court, and the opinion is expected anytime before the end of the 2012-2013 term, which ends, I believe, June 30th.
When you hear that decision coming down, will you be sure to call and let McGraw know, and so he can get you on the show again?
I'd be happy to do that.
All right. Appreciate it. Thank you very much. That's Krista Cox. She's a staff attorney for Knowledge Ecology International, getting us updated on the oral arguments heard yesterday on the case of Monsanto versus Bowman. Very interesting case, because it could have multiple repercussions for farmers down the road of exactly what their rights are to future generations of seed that they purchase at a grain elevator in this case. But if you bought it from a dealer or directly from Monsanto, that they may be able to hinder your rights from taking that seed into multiple generations. It's 6:32. Dan Buck sitting in for McGraw-Millhaven on your Wednesday morning, the day before the calm, or the calm before the storm. There is a big winter storm moving on, and we'll get details on that from Glenn Zimmerman coming up. But first, we're going to check in, I think, on news right after a break. Victoria Babu next.
Mizzou basketball on KTRS is brought to you in part by